Good afternoon. It is my great pleasure to welcome you to this academic ceremony of Maastricht University. I do so in my capacity of Dean of the Faculty of Law and as Pro-Rector representing the university. It is wonderful to see that so many of you have found their way to this aula, very much welcome, or watch this ceremony online. And I welcome in particular the close family of the orator, Ingrid, Erin and Isra, all sitting here on the first row. You are all here for a very special and happy occasion. This afternoon we officially install Professor Roland Pierik to the chair of legal philosophy. And in the Dutch academic tradition, such an installation takes place by way of an inaugural lecture. So in a few minutes, I am very happy to give the floor to Professor Pierik. Before I invite him, I would like to say a few more words about him. And I always do so when welcoming a new professor to our community, explaining why it is that we are happy about the new appointment. In the case of Roland, I'm allowed to call Roland Roland. This is a particularly pleasant task. Your academic career started at the Universiteit Twente, where you studied public administration and defended your PhD on the topic of liberal equality and cultural differences in 2000. And it gives me great pleasure to also welcome both your supervisors here at this ceremony, Professor Huip de Jong, here on the first row, and Professor Wilkem Likka, participating online. You then worked at Tilburg University in the famous pioneer group of Wiebren van der Burg, also present here, and in Nijmegen, before moving to the Universiteit van Amsterdam. And in Amsterdam, if I may say that, you became a real jurist, teaching legal philosophy, acting as the director of the Paul Scholte Institute for Jurisprudence, and as PhD Dean, next to all the other things that you have done at the faculty in Amsterdam. And then on the 1st of August last year, you were appointed to the chair of legal philosophy here at this university. Also immediately taken up the position of chair of the Department of Foundations of Law, for which I am truly grateful. So how did we get to know you here in Maastricht in the last year and a half? Well, first of all, as a very active, energetic and visible colleague, taking many initiatives and always doing so in a joyful way. When you teach your students, you like it in particular if your students do not agree with you and develop their own critical views, which leads you to also enthusiastically telling your colleagues when returning from a lecture or a tutorial, telling your colleagues about these great student encounters. You also are always available for colleagues, not only in your own department, but throughout the entire faculty. I think it's quite an achievement that everyone in the faculty knows you, Roland, in that year and a half since you have been with us. That often also leads to long discussions until sometimes late at night about academic things. In that sense, you're also a very worthy successor to Professor Jaap Hage, also present here in this room, who had this very same mindset focused on discussion. When you arrived in Maastricht here with us last summer, and I told you that our building normally closes at 9 in the evening, that is, you were a bit disappointed by that, because you in fact wanted to stay there for much longer, continuing your discussions. By the way, my spies also told me that if you work together with Roland on an article or a book, it may also be that you find yourself exchanging views on Saturday morning at 6. So be prepared. It only shows how generous you are as an academic, always willing to share your knowledge and views and to help out. And if there is a reason for celebration, you're also the first to congratulate and bring presents. So also there in your early days already here in Maastricht, we saw a lot of vlaai passing by on your Twitter X account. We also learned that you thrive when doing many things at the same time and work under high pressure. Dear attendees, you may wonder what Roland then does to relax, to blow off steam. I only recently learned that you have a very special hobby in that respect. A hobby I have never encountered before with anyone else. You like to travel the world to visit extreme roller coasters. Achtbanen, as we say in Dutch. And to root down these roller coasters as fast as you can. The higher and faster, the better it is. I'm not sure, Roland, why you kept that from us during the interview stage here in Maastricht, but you did. And perhaps I should also warn the members of your department that the next department trip will be exciting. There is still one last thing I like to mention here, and that is also, I think, telling for the person that you are. You stand for what you believe in, also if this goes against the mainstream. For example, your views of vaccination did not go unnoticed. You expressed these views widely in the media in the COVID period, on radio and TV, and among your 4,000 followers on X, Twitter. This also led to lots of, let's call it, love letters that you received, love letters that you also collect on your own website. And just to quote only one of your fans, and I quote, "You are, according to this fan of yours, een ontiegelijk domme boerenlul die geen moer weet van vaccinaties." During COVID, you continued to stand up for your views at the expense of threats, in the belief that government policy must always be based on sound scientific analysis and evidence. So you are not a legal philosopher who is only high up in that tower, high up in that roller coaster, but also one who is really willing and able to come down again in that roller coaster very fast to the street level. Of course, the roller coaster always goes up again. Professor Pierik, I now invite you to come forward and give your inaugural address entitled On the Necessity of Judicial Review for Democratic Governance.
Dear Pro-Rector, dear colleagues, friends and family. Constitutional courts have been criticized for unduly interfering in the outcomes of democratic processes. Such criticism made the headlines a year ago when the Netanyahu administration in Israel introduced a sweeping package of judicial overhaul. The aim was to curb the influence of the Supreme Court. The proposals included a bill that would allow a simple majority in Parliament to overturn Supreme Court decisions. The bill also included a proposal to limit the way the court could employ the Constitution to review executive measures. This move by the Netanyahu administration led to an unprecedented protest from the Supreme Court judges, who usually keep a very low profile. Moreover, 10 months in a row, hundreds of thousands of Israelis took to the streets and demonstrated against these proposals week after week. Similar attempts to overhaul the judicial system have been made by the administrations of Poland and Hungary. These attempts to limit the power of the Supreme Court met with similarly fierce protest, both in the legal community and on the streets. Finally, the European Court of Human Rights has been criticized for unduly interfering in the outcomes of democratic decision-making processes. Some argue that the unelected activists in robes in Strasbourg should not interfere with democratically supported decisions that were made by national governments. In my lecture today, I want to focus on rights-based judicial review. In such cases, the highest court in the judicial system determines whether a specific legislative or executive measure is in violation of a fundamental right that is constitutionally protected. For example, does a measure threaten the freedom of religion or the freedom of expression? Basically, judicial review comes in two versions. In the strong version, constitutional courts have the authority to decline to apply a state act in a particular situation because it is incompatible with the Constitution. This kind of decision implies that the measure is invalidated or annulled. In the weak version of judicial review, constitutional courts can only declare that the legislative or executive measure is incompatible with the Constitution. The court cannot invalidate or annul the state acts. The declaration is only advice. It is up to the administration to decide whether the measure is implemented or not. Let me apply this distinction to the Israeli example that I mentioned earlier. The Netanyahu administration criticized the current practice of strong judicial review by the Supreme Court and sought to transform the practice into a practice of a weak judicial review. The protesters in the street, on the other hand, were strongly in favor of holding on to the strong version of judicial review. They wanted to leave the final decision-making power in the hands of the Supreme Court as a counterweight to the power of the administration. We can observe two simultaneous developments. First, various administrations seek to limit the power of the Supreme Court. Second, the administrations of Israel, Hungary, and Poland have themselves been accused of having authoritarian traits. Recently, a number of books have been published with telling titles like How Democracies Die and Strongmen. These books emphasize how administrations, once elected in office, seek to increase their power by gradually eroding the system from within, by undermining the rule of law and the protection of fundamental rights. In these examples, we see a tug-of-war between the executive and the judicial branch of government. They fight about who should have the final say in important decisions about the enforcement of fundamental rights. In my lecture today, I will use these actual political examples to refer to long-running legal philosophical discussions about judicial review. But I will move away from domestic cases. My main interest today is in how we can understand judicial review within the context of the newly emerging European constitutional sphere. I will therefore primarily focus on judicial review by the European Court of Human Rights. My argument today has three steps. In the first part of the lecture, I will present the general legal philosophical background of the discussion on judicial review. In the second part, I will employ this legal philosophical background to analyze judicial review as exercised by the European Court of Human Rights. The third part of the lecture will provide a normative evaluation of the role the European Court of Human Rights should play in the European constitutional landscape. I will argue that the Strasbourg Court should pursue a path towards stronger judicial review. So let's start with the first part, the theoretical background. For legal philosophers, these debates on judicial review are very relevant because they are intimately linked to the constitutional democratic character of our societies. To understand the core of these discussions, it is important to realize that the term constitutional democracy does not refer to one single tradition. It is a composite term that refers to two distinct and sometimes conflicting strands of thought: constitutionalism and democracy. Democracy is linked to the Republican tradition, which is historically associated with the work of Jean-Jacques Rousseau. Constitutionalism refers to the liberal tradition, which has its historic roots in the work of John Locke. Constitutional democracy is a permanent balancing exercise between its two foundational ideals. On the one hand, a democratic method of self-governance, on the other hand, the protection of fundamental rights through the Constitution. And this dichotomy dovetails very nicely with the two main views on judicial review. Let us first look at the Republican tradition. Republicans are fervent critics of strong judicial review. Jeremy Waldron, for example, argues that strong judicial review is politically illegitimate and a violation of democratic values. This is because it leaves important decisions on society to a small number of what he thinks to be unelected and unaccountable judges. Waldron argues that this undermines cherished principles of democratic representation and political equality. Another critic is Richard Bellamy, who prefers a parliamentary model of rights review and only a weak form of judicial review. In short, these Republicans lean heavily towards democratically regulated politics. They emphasize political equality and argue that the majority rule in democracy should always prevail. In the Republican tradition, the role of the Constitution has faded to the background. This brings us to those who lean more to the constitutional side. Liberals seek to balance the democratic and the constitutional. They move away from the view that the political governance only revolves around democratic decision-making processes and also emphasize the principle of legality. The Constitution determines the rules of the game of legitimate democratic decision-making. Thus, the executive branch only has those powers that are expressly conferred on it by the Constitution. And it is the task of the judicial branch, through the process of judicial review, to evaluate democratic outcomes against constitutional norms. One does not have to be convinced that the democratic majorities are unduly partisan to acknowledge that the majority democratic process is sometimes less attentive to minorities and their fundamental rights. The lawmaking process is under constant time pressure because there are too many complex pieces of legislation to deal with. This will sometimes preclude legislators from making a thorough analysis of the potential negative implications on fundamental rights, especially when they need to legislate hastily in response to a crisis. In other cases, however, the human rights of minorities are explicitly disregarded. A telling example is the Orban administration in Hungary, which for years has knowingly violated the fundamental rights of the LGBTQ community. Sometimes minority rights are curbed unintentionally. Sometimes they are violated deliberately. But Eileen Kavanagh is right when she argues that most, I quote, most elected politicians typically view minority rights as best as side constraints on their political goals, rather than as navigational lights for the political endeavor. Rights-based judicial review can repair such legislative blind spots. We can think of the constitutional democratic system as a two-step strategy that can remedy such democratic deficiencies. The main bulk of lawmaking and law implementation is done democratically. The recursive second step of judicial review is the smoking out and removal of those decisions that, in hindsight, violate fundamental rights. It is important to note that those in favor of strong judicial review do not dispute the central role of representative democracy, but they believe that democratic decision-making alone does not represent a complete picture of democratic governance. Strong and independent constitutional review has a supplementary but indispensable role. It provides an additional layer of governmental accountability in the process of checks and balances. A defense of judicial review does not rest on the capacity of constitutional courts to bring about the right answers to questions on human rights. Instead, such a defense is based on the capacity to counteract particularly bad answers. We can see a clear difference between the two traditions and two views on judicial review. On the one hand, Republicans are confident that the democratic process provides sufficient protection for fundamental rights. They don't want unaccountable judges to interfere with the outcomes of that process. They are in favor of weak judicial review. I find myself in agreement with liberals who are in favor of strong judicial review. They see it as an additional layer of governmental accountability. Strong judicial review provides an impartial check to make sure that the executive measures do not violate fundamental rights. For liberals, the recursive two-step strategy embodies the essence of the separation of powers. The system of checks and balances helps to prevent the state administrations from abusing their powers. Let me conclude this first part of the lecture by emphasizing two things. First, the distinction between strong and weak judicial review is not like an on-off light switch. It is more like a dimmer. Judicial review can be strong, weak, or somewhere in between. Second, it should also be clear that the form of judicial review in a particular system is not set in stone. It can and actually does change over time. Think back to the example of judicial overhaul in Israel. If the Netanyahu administration is successful, that will generate a significant change from strong to weak judicial review. On the other hand, we can also observe the process of competence creep in which courts, verdict by verdict, seek to strengthen their power as judicial reviewers. This brings me to the second part of my lecture. How can we characterize judicial review in the Netherlands and in Europe? Does the Netherlands have a system of strong judicial review? The short answer to this question is no. Article 120 of the Constitution prevents the Supreme Court from reviewing state acts against the Grondwet. At the same time, this answer is too short. It is too short because it presupposes that only the national constitution is relevant here. But as my colleague at the UvA, Leonard Besseling has argued, the study of constitutional review in the Netherlands makes it clear that the concept of constitution stands in need of reconsideration. Indeed, in the current era of Europeanization, we should focus on the wider concept of constitutionality, and this includes also other norms and institutions with constitutional relevance. One example of this is, of course, the European Union. More relevant for our discussion today are the Council of Europe and the European Court of Human Rights. The Council of Europe was founded in 1949 in response to the horrors of the Second World War. The aim of the Council was to achieve greater unity between like-minded European countries and the common heritage of political traditions, ideals, freedom, and the rule of law. To achieve this goal, the Council of Europe established two very important institutions: the European Convention on Human Rights and the European Court of Human Rights. The emergence of the European Court of Human Rights has changed the terms of the discussion on judicial review. What is new is that it now concerns interactions between national authorities and a supranational court. The question in the second part of the lecture is, how should we characterize rights-based judicial review by the European Court of Human Rights? As weak, as strong, or as something in between? Article 1 of the European Convention determines that national authorities have the primary responsibility for ensuring effective protection of fundamental rights. The European Court of Human Rights only has a subsidiary task. It mainly involves checking after the fact whether national authorities have indeed complied with their obligations under the Convention. The idea of subsidiarity also implies that the Court gives national authorities some leeway regarding how they fulfill their Convention-related obligations. This means that states can implement their obligations in ways that best suit their national identity and constitutional tradition. This leeway is called the margin of appreciation. By signing and ratifying the European Convention, the states have transferred their sovereignty concerning the observance and enforcement of human rights to the European Court of Human Rights. Article 32 of the European Convention states that, in the event of a dispute as to whether the court has jurisdiction, the court shall decide. Thus, the court has the final say, not the state, but the court. Article 46 determines that the states undertake to abide by the final decision of the court in any case to which they are parties. Thus, the states agree that the court decides and they have to follow. A strict legal reading of these two articles would lead to the preliminary conclusion that from the very start, the European Court had the competence to exercise strong judicial review. However, in the first period of the Convention system, say between 1960 and 1975, the European Court acted very carefully and with much self-restraint. It invoked human rights diplomacy rather than challenging national sovereignty. First and foremost, the Court sought to gain legitimacy in the newly developing European constitutional landscape. From this, I draw the conclusion that in its first phase, the judicial review exercised by the European Court was very weak. It is not a coincidence that in this period is characterized as the sleeping beauty years of the European Convention. But around the mid-70s, Sleeping Beauty woke up. Judgment by judgment, the court carved out for itself the authority to develop its own jurisprudence. It became increasingly independent, departing from the original intent of the states that had signed the Convention. In one judgment, the court determined that it should interpret the Convention in light of its object and purpose, rather than narrowly as a treaty between sovereign states. In another judgment, the court determines that the Convention ought to be seen as a living instrument of development and improvement, and must be read in the light of changing circumstances. And in yet another judgment, the court declared that the Convention rights must be interpreted in a way that make them practical and effective rather than theoretical and illusory. Taken together, the various judgments strengthen the position of the European Court as an independent interpreter of the European Convention. The Court increasingly decoupled the interpretation of the Convention from the will of the contracting states. Armin van Bordandi and Christoph Ken conclude that the Court increasingly interpreted the Convention rights as autonomous, dynamic, and destined to effectively limit the discretion of national authorities. Earlier, I concluded that in the first phase, the Court exercised a weak form of judicial review. In this second phase, the Court found its voice in entrenching the European Convention in the European legal space. My conclusion is that the Court exercised a much stronger form of judicial review in this second phase. However, within the European constitutional space, the European Court must share the legal competence to exercise judicial review with the national constitutional courts. The European Court cannot give a verdict on whether a legislative or executive measure by a convention state is legally valid. This assessment can only be done through domestic judicial review based on domestic constitutional law. Thus, the European Court of Human Rights cannot invalidate or annul a state act. On the other hand, the European Court has the legal competence to make binding judgments on citizens' complaints alleging that a state has violated a convention right. Thus, the European Court can only exercise judicial review within a legal domain as demarcated by the rights of the European Convention. However, within the domain, the European Court does exercise strong judicial review. A judgment of the European Court that a state has violated a convention right has binding power. It is a strong form of judicial review because such a verdict cannot be reversed by a decision of a national parliament. The European Court entered the third phase around 1995, in which the convention states started grumbling. They argued that the court has gone too far and too fast in its extensive interpretation of the scope of convention rights. However, since the verdicts of the European Court are legally binding, state parties had to find another way of showing their discontent. A telling example is the infamous and my favorite case, the Lauzi case of 2011. If only that I could give this picture for you. The case against the Italian state was brought by the European Court by Ms. Lauzi, an atheist and a mother of 2 young children. She objected to the crucifixes that were mandatory and very prominently placed in the classrooms of the public school her children attended. In the first instance, the European Court agreed with Ms. Lauzi that the mandatory presence of crucifixes in public schools was a violation of Article 9 of the Convention. The Italian government objected to this decision by the courts, objected to this discussion by the European Court, and appealed immediately. Silvio Berlusconi, the Italian Prime Minister at the time, did not mince his words. I quote, "This decision is not acceptable for us Italians. It is one of those decisions that make us doubt Europe's common sense." Italy's undisguised threat that if the Italy's undisguised threat was that if the judgment was upheld, it would openly and explicitly ignore its implications. And more importantly, Italy stood not alone. 10 other convention states vowed to support Italy. This massive and manifest rebellion against generated a real dilemma for the European courts. It realized that its legitimacy would be damaged beyond repair if it maintained the Lautschi verdict. Thus, on appeal, the court made a U-turn, and the doctrine of the margin of appreciation was invoked to avoid the conflict. On appeal, the Strasbourg court concluded that it was up to the Italian administration to make its own decisions on these matters. The Lautschi case makes clear that there is a tension within the convention structure. On the one hand, the participating states that established the European Court as an external and independent supranational arbiter on the concrete content of the convention rights in specific situations. On the other hand, as a supranational court, it is critically dependent on the continuing support of the states. The court can only maintain its legitimacy if the states more or less consistently comply with its judgments. It seems very plausible that the European Court backed down after the explicit threat that 10 convention states would openly defy such a high-profile judgment. I can now answer the main question asked in the second section of the lecture. From a narrow legal perspective, it seems that the European Court of Human Rights, within a domain demarcated by the European Convention, can exercise strong judicial review. It has the power either to make a final judgment or to declare that the margin of appreciation is applicable. At the same time, given the political context in which the court unavoidably operates, it remains critically dependent on the continuing support of the state parties. This leads to my conclusion that the European Court of Human Rights exercises a weakened form of strong judicial review. After all, the court has always the convention states in its rearview mirror, and as the Lautschi case made clear, sometimes the objects in the mirror are closer than they appear. This brings me to the third and final part of my lecture. Should the European Court of Human Rights, in the near future, pursue a path towards weaker or stronger judicial review? In the Lautschi case, one thing became very clear. The European Court can only effectively fulfill its role as a European guardian of human rights if it can maintain the long-term loyalty of state parties. This implies that the Court's decisions cannot deviate too much from the European consensus on the meaning of convention rights. On the other hand, being too differential to state parties also severely endangers the Court's legitimacy. But now in the eyes of citizens, who rely on the Court to protect their fundamental rights against state actions. Being too lenient to state parties undermines the Court's key task of protecting human rights. In this sense, the Court finds itself between a rock and a hard place. And this tension can be illuminated by returning to the first part of the lecture and the legal philosophical discussion that Republicans and liberals are engaged in. Oh, wait, I missed this one. In this debate on the judicial review by the European Court of Human Rights, Republicans emphasize the importance of a persistent and explicit democratic oversight of the European Court by state parties. Richard Bellamy believes that the Court should maintain a low profile. He still conceives the European Convention narrowly as a voluntary treaty between sovereign states. He rejects the idea that over time the Convention has increasingly acquired a constitutional status. He thus concludes that the European Court should only exercise weak judicial review, keeping the Convention states firmly at the steering wheel. On the other hand, liberals like Alexander Somak and Jorge Letsas advocate a much stronger role for the European courts. They argue that the preamble of the Convention has clearly determined the path the court should follow. The primary goal of the evolutive interpretation of the Convention rights must be the achievement of greater unity between state parties. And this should be accomplished through the maintenance and thorough realization of human rights and fundamental freedoms. Let's go as far as to argue that, I quote, "The purpose of human rights treaties, unlike that of many other international treaties, is to protect the autonomy of individuals against the majoritarian will of their state, rather than give effect to that will." This leads to the conclusion that the European Court of Human Rights should take the lead in the protection of human rights by exercising strong judicial review. I find myself somewhere in the middle of this debate, but I lean towards the liberal side. I think we have seen two important developments over the last 5 decades. The first is that we have moved beyond the point where the European Convention can merely be understood as a voluntary agreement between state parties. Over time, it has obtained a constitutional, or at least a semi-constitutional status. Secondly, a robust European consensus has gradually emerged that strengthens a common understanding of human rights into the fabric of the Convention. On the basis of this emerging consensus, the European Court has created an impressive body of jurisprudence. In this case law, each and every Convention right is interpreted and applied in an authoritative manner. In that sense, we can acknowledge the emergence of something like that we could call Convention constitutionalism. The European Court of Human Rights has an important role to play in the ongoing dialogue with state parties. It should take the role of a catalyst in the continual process of further strengthening and cementing a European consensus of what Convention rights mean. The incremental interpretation of the European Convention is a delicate balancing act. In specific decisions, it might be hard for the court to determine whether it can presume that there is already an established European consensus in favor of a further step being taken in human rights strengthening jurisprudence. The risk of non-compliance by Convention states was loud and clear in reaction to the first Lauzi verdict. In other cases, the resentment by the states might be more ambiguous, harder to detect, or might build up over time. The incremental interpretation is a gradual process of 2 steps forward and sometimes 1 step back. This also implies that the court must sometimes accept that it has to back down when a specific verdict generates too much opposition, as we saw in the Lauzi case. 2 steps forward, sometimes 1 step back. The European Court of Human Rights can only fulfill the aspirational role it has. The European Court of Human Rights can only fulfill the aspirational role it has been imbued with in the preamble of the Convention, when it holds on to its leading role towards developing this conventional constitutionalism in Europe. Let me summarize the argument. Democratic governance not only implies democratic decision-making procedures, but also the protection of constitutional essentials, the rule of law and fundamental rights. Strong judicial review provides an essential additional layer of governmental accountability and checks and balances in the process of democratic governance. In the last 5 decades, the European Court of Human Rights has carved out for itself a central position in the European constitutional landscape. It has become the key actor in the process of the observance and enforcement of human rights. Strong judicial review by the European Court of Human Rights is necessary for democratic governance within Europe. I come to my conclusion. The hardest part of preparing this inaugural lecture was not the writing of the text. The hardest part was stop writing. There are so many themes that I could have included, arguments that I should not ignore, academic puzzles that should have been tackled. In this sense, this inaugural lecture is not a finalized text. It is merely work in progress and a starting point of various research strands I would like to develop in the coming years. I am interested in how the idea of constitutionality will develop in the emerging European constitutional space, in the triangle of national constitutional courts, the Court of Justice of the European Union, and the European Court of Human Rights. I am interested in how the power struggle between the European courts and national administrations will develop. And I'm convinced that the philosophy of law can make important contributions to a better understanding of these developments. The law faculty of Maastricht University, being a truly European faculty, is an excellent place to further explore my chosen research themes in what is sometimes called the field of normative constitutionalism. I'm looking forward to collaborating with colleagues in European and constitutional law on these themes. But first and foremost, I'm looking forward to the ongoing collaboration within our Department of Foundations of Law. I arrived in what I only later realized a very well-functioning organization. It was a very well-functioning organization, and it took me a while to find it out. In addition, we were able to further strengthen the department by hiring some new scholars. In the last year, we have set all kinds of new activities into motion. We renamed the department. We started or restarted the Maastricht Foundations of Law Colloquia. We developed 3 brand new master courses. And other initiatives that started long before I arrived are also thriving. Think of the Roundtable on Law and Popular Culture. And next spring, we will kickstart our new research center, the Maastricht Institute for Law and Jurisprudence. Dear colleagues, it is a genuine privilege and a joy to collaborate with you all in our Foundations department. I'm very much looking forward to participating in all our future endeavors. I thank the board of Maastricht University for the confidence placed in me and for having appointed me as the chair of legal philosophy in the Faculty of Law. I also want to thank our dean, Jan Smits. He enabled me to make a soft landing and a running start simultaneously. Those who know something about aviation techniques might insist that this is impossible. You can't have both a soft landing and a running start, but our dean can make things possible. I want to thank my predecessor, Jaap Hagen, who proactively helped me from the very start to settle easily in the department. Dear colleagues, friends and family, here in the aula and online. Thank you all very much for joining me here today. I see delegates from all the universities where I've been working in my academic journey. Twente University, Tilburg University, Radboud University Nijmegen, University of Amsterdam, and of course, my new University of Maastricht University. I genuinely hope, really, that you didn't come only to Maastricht for the lecture, because I would also like to join me later in the after party over there. It means a lot to me to see so many new, old, and very old friends here gathered today. As the saying goes, it takes a village to raise a child. Well, it takes a global academic village to train an academic. I want to thank my PhD supervisors, Huib de Jong here, and Wil Kimlicka in Canada, but I also want to thank Wiebren van der Burg, who welcomed me as a postdoc in his pioneer project and helped me to kickstart my academic career. I also want to thank many collaborators and co-authors. To name a few: Ingrid Robijns, Wouter Werner, Meike Houwezel, Stefan Rummens, Mark de Wilde, and Marcel van Wij. They have helped me to develop my ideas, and they have made academic life so much more fun. Dear former and current PhD students, Jeff, Hadassah, Tamar, Lars, Steven, Eline, Adelheid. It was and is a pleasure to work with you. Supervising PhD students is the icing on the cake of academic work. En aan het einde een paar woorden in het Nederlands. Een speciaal woord van dank voor mijn Nederlandse en Vlaamse familie, die vandaag in grote getale hier aanwezig is. Een heel speciaal woord van dank voor mijn kleine zusje Charlotte, zonder wiens hulp het Robijns-Pierik huishouden regelmatig in het 100 zou lopen. Mijn laatste woorden van vandaag zijn voor de 3 meest belangrijke mensen in mijn leven. Lieve Ern en Isha, jullie hebben je de afgelopen jaren op verschillende, maar beide op een zeer bijzondere manier ontwikkeld. Het is erg mooi om dit proces van zo dichtbij mee te maken. Ik ben erg trots op jullie en ik vind het heel fijn dat jullie er zijn vandaag. Lieve Ingrid, ik zie je kijken. Wat gaat u zeggen? Lieve Ingrid, het cliché is waar. Zonder jou had ik hier vandaag niet gestaan. Mijn baan in Maastricht heeft jouw leven veel complexer gemaakt en toch heb je me vanaf het begin van harte gesteund in deze beslissing. We zijn beide academicus en dit academische is zeer bepalend voor de manier waarop we samen ons leven hebben ingericht. Maar naast het academische is er nog zoveel meer. Dat maakt mijn leven met jou heel bijzonder. Dank daarvoor. Ik heb gezegd.
Yes, thank you so much. Thank you so much, Professor Pierik, for this inaugural lecture. Also the first time that you are allowed to officially wear the gown of Maastricht University. That's special. In your case, I think even more special. As you were born, I did not mention that yet, as you were born in the town of Rijssen, which is known throughout the world as the fashion capital of the East, as I learned recently. Thank you so much. Many congratulations to you on this appointment. And I, of course, also congratulate your wife Ingrid and your children Erin and Ischa and all your other family and friends present here in this aula and watching the ceremony online. We are slowly reaching the end of this session. I want to thank you all for joining. I do have one practical remark. There will indeed be an after party. We also call this the reception here in Maastricht. And to everyone here in the aula, I would like to welcome you all to this reception taking place in the refectory here in this building, where we're able to congratulate Professor Pierik. To all the participants online, you cannot participate in the after party here, but I would like to invite you all to propose a toast to Professor Pierik. And with this, I also officially close this academic ceremony.